If they were willing to allow it.
Absolutely required.
Or I wonder if there's a place to
And you even have to chat, you have to talk.
that's
I could have said no. I gave you the option.
hello, Maxine.
Yeah, I mean, we have other options. I think the board needs to discuss this.
So, Brad,
It's just on that right now.
so you're first, right?
I do believe so.
I'm doing it for the meeting, right? Matt's not, so you're next to me there.
Right.
Sure, we'll take all questions. Don't worry about it. Yeah. Yeah.
Dora, hello. How are you?
I'm great, thank you. How are you?
That's a direct quote.
Mr. Mayor?
Hey, give Rachel a couple of minutes.
Sorry. I'm thinking you're talking about here or not. I'm thinking of this as a meeting, not
Don't forget the donut.
When I like your colors.
Thank you. You too. Feels
Festive.
We'll still allow you to
Thanks,
come
5
in
days.
December. Is that okay?
Yeah, it's 5 days. Yeah, I can't wait.
Of course you will.
Well, we can remind, I think it's probably a good thing to remind everybody on Thursday that if the signs aren't down, they only got 3 days left.
yeah. They got the weekend.
They better not be there, they better not be there Tuesday morning when they go out and start looking. Yeah, our guys cleaning up the streets.
No, we don't clean them up. Here's my.
I get the sense that he is kind of buffaloing right now.
They make
Wait till the day of.
Now, the pattern across your yard?
well, the area where you don't want the grass to
Okay,
grow.
now we can start.
Longer than any of us can allow it, as long as we get some.
Good afternoon, ladies and gentlemen. I'll call to order the regular work session for the City of Sierra Vista for 6 November 2018. We're going to start today with the presentation on the items for the council meeting for the 8th. And of course, we'll do the roll call, the pledge and the invocation, acceptance of the agenda, the awards presentation for, we have some certificates of appreciation for the Sister Cities Commissioners. And then the city manager is going to give us his briefing, his report. First two items are the consent agenda. One is the approval of the city council minutes for October 25th, 2018. Does anybody have any additions, corrections, completion, or comments for item 2.1? Seeing that, item 2.2 on the consent agenda is approval of the city council special meeting minutes. Anybody have any additional any comments, corrections for that one?
Nope.
Seeing none, we'll move on to 2.3. And that's 2.3 is just the reappointment of Bill Bates and John Walsh to the Library Commission. Any comments or discussion? All right, we'll move on to new business.
Actually, do have a question.
Go ahead.
I think on Mr. Bates' application, it said, is he currently a city
Yes,
employee?
No,
Oh, he used to be a city employee.
I don't know. He's being
I don't think so.
reappointed, so.
he's being reappointed.
I'd have to look and see. The name doesn't ring a bell.
He used to be on the commission.
Doesn't ring a bell.
Okay, it just, yeah, I was just wondering if that was, if that was an issue or not.
I will check.
Thank you.
Yeah, if he's been on the commission before and served all his terms, he has to sit out a year and he can come back.
Right,
So
it
that's,
just said
yeah.
City of Sierra Vista employee.
Okay, all right. I don't think he was, but, okay, good. Now move to item number 3, and that is the acceptance of the Redmond annexation. Ms. Moore.
Hi, Mr. Mayor, council members. Hopefully that will show up. This is the final step for the Redmond annexation. With approval of this ordinance, the annexation of the 2 properties owned by the Redmonds will be finalized in 30 days. The properties are located off Little Hill Road, and actually we have the map. It is just east of the Oakmont subdivision off Avenida Cochise. With the completion of the annexation, both properties will be subject to city taxations and regulation. The acre properties will be zoned SFR 36. I'll be happy to answer any questions you have. Yes, ma'am.
Were there any letters or anything opposing it or supporting?
No, ma'am, this is just one property owner that requested to be annexed, so therefore he signed a petition.
The question I got is about this diagram. It's different than the one we saw before. Basically, the difference is we were also annexing that section of Little Hill Road, Little Hill Lane that connects the property to the city.
You're correct. I will have this changed before the meeting.
Okay, so this is the incorrect one.
Correct. This is just the two parcels
Gotcha.
boundaries.
Yeah.
Apologize for
Okay.
that.
Yeah, but the thing is, it'll connect.
Show us.
It'll connect. It's in the book, like the proper one's in your book. Okay, don't have your book. Sorry. Okay. Any other questions? The reason I raise that is because it looks like we're annexing an island, which we're not allowed to do legally.
I see.
Yeah.
Thank you. That's
Yeah,
good to know.
that's why
I remember that other picture.
Yeah, there's a little leg there that sticks
Yeah.
out. Okay.
And it's part of his property, or?
Well, it's
just
part of,
there?
we're annexing that as well, the right of way, and
Okay,
we're taking
it's-
over the road,
it's empty.
we're taking over the road maintenance as well for that piece, because it'll be in the city now. Okay? Anything else?
Do you remember that?
Thank you, Ms. Moore, appreciate it. We'll next move on to item number 4, which is the granting of land exchange with Mr. Davis, City of Sierra Vista with Mr. Davis, Mr. Pregler.
Hopefully this map will show up as well. Great. Thank you, Mr. Mayor and members of council. Yes, this is a land exchange request between the AAA Fort Storage and the City of Sierra Vista. If you look at the map, you'll notice the general location is north of Cayetan Drive, east of North Avenue. The applicant's property has the storage facilities over here, and the city property, which is part of the Soldiers Creek Linear Park, located right here. And the land exchange will be between these two separate properties right here. I'll show you a better map as we continue on. The owner of AAA Fort Storage submitted a site plan to the city to allow an expansion of the existing self-storage business. During the review process, it was discovered that portions of an existing perimeter wall encroached into the adjacent city-owned property. And I have a map here of the area to show you exactly where the wall is located. And following my pen here, this black line is the wall, and this line here is the property. The wall goes up through here, and then once again it crosses the property over north of the this building right here. So, as an alternative to removing the wall, the owner is requesting an exchange of property. Portions of the wall located. Will also have the effect of transferring portions of the floodplain area currently located on AAA Fort Storage to the city. So this is look at these next to each other here. Let's see if I can. There we go. So you'll notice the areas in blue are going to the AAA Fort Storage, and again, they kind of follow the same pattern that you see on this map here. This is going to AAA Fort Storage. This is going to AAA Fort Storage up here. And then the areas in red will be deeded to the city. Again, the area right here and the area south of here will be all given to the city. So the total area received by the city will be 901 square feet, and the total area received by the applicant will be 900.9 square feet. So there'll be an equal exchange of property. The proper notice was given per state law. There are required to be 4 legal ads to the newspaper prior to the public hearing, and that was done. And so this concludes staff's report. Any questions you may have?
Questions from the council? Yeah, all we're doing is this map revision, and the key thing in my mind is the property values are basically the same, so we don't get into this gifting clause crap that's a concern of this legislature.
That is correct.
Okay. Excuse me for my language. I didn't mean to offend you, Gwen.
No, you didn't offend me. I was just surprised. Sorry.
Said a lot worse. I'm proud of you.
So my question is, Jeff,
Jeff,
sorry.
you
Gotta leave on that note. I
You have to
couldn't
give us
top that.
You have to give us giggle time. How long has that wall been there?
That is an excellent
Forever?
question. It was unpermitted, so I don't know when that wall was constructed.
Oh. The other question,
we're being nice and not fining him for not permitting.
he may
Building
not.
a
do you
construction
think-
that was unpermitted.
And I was wondering if there's a disadvantage to us. You mentioned floodplain, and I wondered where that fits into the bigger picture.
Right. So those areas on AAA Fort Storage property are currently in the floodplain. So what basically we're doing is taking those off of the private property, moving those areas into the city. Right now it's Soldiers Creek Linear Park. That's all within the floodplain area. Mm-hmm. It's undevelopable. Mm-hmm. So there's no sense in them keeping that property. So they can go ahead and dedicate that to us. So it's all within the city.
We already have like
property.
99% of that floodplain anyways, so.
Correct.
It's west of where the old yard was.
Okay. Thank you.
You got it.
Okay. Anybody else? Thank you, Jeff. And you're gonna step up. You're gonna step in for the land exchange on item number 5.
Yes.
Yeah, this is a little more complicated.
How do you zoom on this? Just autofocus? Okay. Good afternoon, Mayor, members of council. Staff is seeking your input and direction on a proposed agreement for a land exchange that involves the following. First, the city would acquire a 0.41 acre parcel owned by Robert and Jeffrey Willis that is part of the Fry Pioneer Cemetery, one of the most historically significant properties in Sierra Vista. The founding families of the town and over 200 persons who lived and worked in the area are buried there. Obtaining this property was included in multiple prior City Council strategic plans. Acquisition of this cemetery parcel, together with the parcel to the north, being purchased by the Sierra Vista Historical Society, will provide parking and secure access via 7th Street. The property is referenced as Exhibit A in the ordinance and shown in blue on the map. In exchange, the city would convey 4 parcels provided in Exhibits B1 through B4, shown in red on the map, to the Willis family. 3 of the parcels were acquired via the Balmer Settlement Agreement, and the property on Maccabee Street was deeded to the city from the Pascua Yaqui tribe. Frank Morrow, the commercial broker, has evaluated the land exchange and determined that the properties being traded are of substantially equal value based on his research of recent comparable sales. Once conveyed, the agreement calls for Pioneer Title Holding Company to buy the city parcels from Robert and Jeffrey Willis for $73,654, their estimated value according to the Cochise County Assessor's Office. Pioneer Title's intent is to assist local nonprofit agencies to repurpose the city property as affordable housing that would ultimately benefit the community. This matches the city's original intent when it deeded the 2 parcels to Habitat for Humanity before those parcels reverted back to the city following their dissolution. I received confirmation this morning that the 2-year commercial lease that was disclosed in the MOU will be terminated prior to the land exchange taking place, so we won't have to deal with relocation. The guy that was contemplating doing a car lot there is moving on to El Paso. So the proposed land exchange has been advertised in the newspaper in accordance with state statutes. If you grant approval, we'll need to wait the 30 days after your meeting on Thursday for the ordinance to take effect to proceed with the land exchange. The targeted date for closing is December 21st, 2018, which shouldn't be a problem. And with that, I'll answer any questions. And Frank Morrow is here if you want further explanation on the valuation.
Questions?
I do have a question. Did you say the valuation, and Frank, you might have to answer this, but the valuation came from the assessor's office or from your comparables?
On the properties we own, it came from the assessor's office. We didn't want to expend money on independent appraisal. They're generally in line. Frank did some survey based on the Crossing Point subdivision, and they're within an acceptable margin of the county assessor's office. So it's close. And state law says they need to be substantially equal, not perfectly equal.
No, I understand they're not perfectly. Okay.
No questions. I think this looks like a really good deal. I know the city has worked or wanted for a long time to have that property so that we could give proper respect to that cemetery, especially the parking issue. So it looks good to me, and I'm happy to see it's happening.
Anybody else? I just want to say, from dealing with the folks with the Historical Society, this is a key piece of property because there is at least verbal evidence that there may be actually interments on the parcel that has been used for a parking lot. So once that is in city hands, the Historical Society is willing to get the proper radar instruments down to look and verify that we do or do not have interments on parts of that property that we acquire. But in any case, it's a better situation for the west side. And probably, I would assume, a part of that will be used for parking, but maybe not all of it. That's the comment I wanted to make. Any further questions? Mr. Morrow, we appreciate your help on this issue, and we appreciate you being here this afternoon too. We'll go on to item number 6. Joint Powers Agreement, Ms. Yarborough or Mr. Patuchik, who's doing it?
I'll take it first, Mr.
Okay.
Mayor. So thank you. Since the CCOM Center went live in July of 2018, both the city and the county recognized that some necessary changes to the structure of the agreement could benefit the operations overall of the center. And so the amendments to the intergovernmental agreement before you now, the county passed on October 23rd, and they now come before you for approval. The amendments to the IGA include the city would become the fiscal agent for CCOM. Legal representation for CCOM would be provided by an attorney hired by the board. All personnel employed by CCOM would work under the city's personnel rules, class and comp plan, and benefits starting in December. Membership on the board would change to 1 vote per principal and partner member, where the county and the city are both principals and other joining municipalities are partners. And then each principal and partner would select its representative in a manner of its choosing. The county voted at the time that it approved the amendments to the IGA to appoint the sheriff as its representative to the board. And then membership on the operations committee would change to the sheriff's chief deputy or designee instead of the sheriff, along with the chiefs of police and fire departments and chiefs of all participating fire districts, which is not a change on that part. And the chair would be selected for a 1-year term by vote of the committee instead of the sheriff as in the previous IGA. No member of the board could then serve on the operations committee. So again, the county approved these amendments on October 23rd. And the only change the city proposed to the IGA that the county sent over to us was changing the effective date of the CCOM personnel changes from December 11th to December 24th of this year to coincide with payroll.
Periods. Okay. All right. That was my question. Questions, discussion?
Just as a point of clarification, to understand correctly, that all the other, the chief of police for the various cities will serve on the, what did you call it?
The operations
committee. But the sheriff and another appointee from each of the cities will be the board of directors.
The
board.
The county, as a separate member, has decided that the sheriff will be their representative to the board, just like like we have decided that Chuck is a representative of the board, or when other communities come in,
they pick who
they pick what they want, and once we get three fire districts, they will select which one of the chiefs is going to be their representative.
Okay, I think you said it much nicer than I did. Thank you. I think I understand.
Well, no, it's confusing.
Yeah, well, no, it's not that confusing. It's just interesting.
And the question I would ask is, Mr. Patuchek, do you see any problem? You've been dealing with this for quite a while. You see any problem with the way it's structured and the way it's going to have to be managed in the future?
Well, Mr. Mayor, Victoria has certainly presented this probably nicer than I would have. but nonetheless, the CCOM itself is operating very well, and the executive director, Mr. Dugan, is doing a fine job. So in terms of how, it was envisioned to operate, that is working out very well. Obviously, the county had some issues with regards to representation, and they wrestled through that probably over the last couple of months before settling on, instead of having the county administrator plus the sheriff serve ex officio on the board, they've determined that the sheriff would be their member. In terms of our operation, we would take on the fiscal agent responsibilities, so that would be our admin services and the HR responsibilities. Frankly, I feel good about them being here. I'm confident. We've done a lot of these things before. We're well set up and staffed to be able to handle those types of operations. So that's fine. The attorney part, the county attorney's office was representing it, so I'm not totally pleased about that, because that would be an additional cost to CCOM unless Nathan agrees to do it, or we find somebody else, and I can't even think of who that would be at this point. So I'll have to think that through. But
the question then is, will the county do the attorney portion up until that somebody is appointed?
I believe they'll keep going until we're able to work that out. Also, under this agreement, the county would still maintain the IT function and maintenance of the facility. So they're still involved. It's just they're passing these other, duties and responsibilities to the city, which I'm in favor of.
So I guess we always want to understand the financial burdens on the parties taking part in this. And I don't quite get who's doing what and at what cost. So is that something you can, maybe not right?
Yeah, I can give you a pretty good idea right now. The CCOM budget would actually end up being in our budget or presented in some way. David would have to do that. We'd have to set up accounts for that. We have a system in place to do that. So it's not like we'll need to hire additional people or anything like that. Certainly, David and Linda will have a little bit more work to do working with that, but I'm confident that they can do that. On the HR side, we were already dealing with our own dispatchers prior to CCOM, coming into existence. So basically, we would be taking that back and dealing with the county employees, which would then come over as part of that. So a little additional work. We were hoping we could not have the recruiting and all that, but I think we can be more effective at that as well. So I think that'll work out okay.
Chuck, one of the things we haven't seen as a council that may have led to the question is, and I know it's not complete yet, but the new members that come on board, they'll be paying a rate, and I think we probably need to understand what that rate structure is and how that works and what the financial impacts are. We need to know that probably well before the next budget cycle.
Well, right now, since we'll be assisting Mr. Dugan in putting together the budget, over the last couple of months, we've been dealing with the funding formula for the partners to be paying, and we've come up with a number of different ideas. At our last meeting last week, I think we came up with one that will be palatable to everybody concerned and has a rationale behind it. We'll be approving that hopefully Thursday, and then we'll be able to share those numbers with you.
I think we need to understand that. That was my point.
We have two entities ready to come on board as soon as we get that finished.
Okay. Any other questions or discussion? All right. Seeing none, we'll move on. Item number 7, Chief Thrasher.
Thank you, Mr. Mayor, members of council. HIDA stands for High Intensity Drug Trafficking Area. The HIDA program was created by Congress in 1988 and is a Drug Enforcement Administration program that provides assistance to federal, state, local, and tribal law enforcement agencies operating in areas determined to be critical drug trafficking regions within the United States. This program is administered by the Office of National Drug Control Policy, and DEA has nearly 600 special agent positions dedicated to this program. At the state and local level, HIDAs are directed by executive boards composed of equal number of regional, federal, and non-federal law enforcement leaders. The Arizona HIDA was established in 1990 as comprised of 59 federal, state, tribal, and local agencies. The Arizona HIDA's mission is to facilitate, support, and enhance collaborative drug control efforts among law enforcement agencies and community-based organizations to reduce the impact of illegal drug trafficking and use of drugs throughout Arizona. To this end, HIDA DEA forms task forces with state and local agencies throughout the state to disrupt drug trafficking, gather intelligence, conduct investigations, and prosecution of drug traffickers. The agreement before you today is an agreement for the Sierra Vista Police Department to assign 1 officer to the DEA Sierra Vista HIDA Task Force. This task force is supervised by a DEA agent in the Sierra Vista office and specifically targets drug trafficking activity in Cochise County. The agreement allows SVPD to leverage DEA manpower and resources to enhance enforcement efforts within the city. DEA currently has 8 agents assigned to the task force in addition to other local agency participants. In agreement with the local DEA supervisor and the Tucson field office special agent in charge, the SVPD task force officer will have a specific area of responsibility to target local street level and mid-level drug traffickers in Sierra Vista. The officer assigned to the task force will still work out of the police department in conjunction with the task force and the community response team. In addition to manpower and resource benefits from DEA, the agreement opens up resources and funding opportunities directly through Arizona HIDA. Arizona HIDA has committed to reimbursing overtime for the officer assigned to the task force up to $18,000 a year. In addition, many fully funded training and grant-funded equipment opportunities will open up through Arizona HIDA. We have been a member of the HIDA task force in the past, most recently in 2013, 2014. With that, I'll be happy to answer any questions.
Yeah, the question I got right off the bat is, how does this affect the number of officers available on patrol?
It doesn't. We have one of the officers that is currently assigned to the community response team will be assigned as the task force officer. What we've done this time, the reason why we haven't been part of the task force recently is because when we used to assign the officer over there, they would disappear and they'd end up working up in Phoenix and Tucson.
Never see them again, yeah.
I've made a specific agreement with the local supervisor and the field office special agent in charge that they will be dedicated completely to Sierra Vista, and then any of those cases that go up there will be handed off to other agents and other members of the task force.
Okay.
Can you give us a bit of an example of kind of the tactical and operational handover that would take place with them operating?
So they already operate here, and they already do operations within Sierra Vista. What this does is allows us to leverage the intelligence gathering between the 2 agencies. And then for us, we only have 2 officers assigned to the community response team, well, 2 and 3 assigned to drug trafficking. By being able to use task force officers, it would enhance our ability to do search warrants, undercover operations, and those type of things within Sierra Vista.
Would there be any changes to the, well, ironically, the personal rules and regulations for the task force officers that are operating in conjunction with this task force?
They would still follow under ours and also under the DEA's. For operations that they operate with DEA, they'll have to follow their operations model.
Thank you.
Does this in any way represent a recognition of any increase in drug trafficking in this area?
It does not. This task force has been operating here for some time. There are members, Benson, Douglas, the county attorney's office, the sheriff's department have been members of this task force. It just allows us to be able to leverage more opportunity for us to be able to do more work in that area.
Thank you.
Anybody else? Thank you, Chief. Appreciate it. We'll next go on to item number 8, Chief York.
Mr. Mayor and Council, this is a donation that we would like to propose. That we have a 40-foot domestic preparedness trailer that we got through a grant from a 2004 Homeland Security grant. We've got redundant local resources here. The Fry Fire District and Fort Huachuca both have similar resources. and we're kind of trying to downsize or right-size what we have. And Pierce Sunsites Fire Department has volunteered to accept this trailer. I think it makes sense to have it in that part of the county. Douglas also has a similar vehicle over there, so I think that kind of allows us to cover the entire county with similar resources. And it just makes sense for us because we had quite a few of these types of resources, hazmat and this domestic preparedness and special operations, and it just kind of spread us too thin. And we think that this will work better by spreading the resources out and allowing everybody to kind of specialize in a certain area.
So you're confident that we'll be able to get the local support we need from other agencies should we need this type of equipment?
Yes, and what we've done is taken the personnel that we have trained in these areas, and we've attached them to those teams, to either Fry's or Fort Huachuca's team, so they can be part of a call out as needed as well. So they'll represent us and kind of keep us informed on what's going on.
And the cargo trailer is how old?
It's a 2004, so it's 14 years old.
And state of maintenance on the equipment?
I think everything we have is well maintained, and I looked at it the other day, and it's just.
Well, I just don't want to hear from Sunsites that hey, Sierra Vista gave us a 14-year-old trailer.
Well, we will be though. It's
yeah,
a 14-year-old trailer,
and it looked like a 24-year-old trailer. You know what I'm saying?
No, it's actually in pretty decent repair.
Okay.
Yeah.
All right.
One other comment. Excuse me. Is it just a trailer or is there equipment in it?
There's some equipment in there.
Did I hear you mention hazmat stuff? But whatever's in it is stuff that's also redundant? Is
Yes.
that what you're saying?
Yes.
Okay.
The stuff that we don't need that should stay with the trailer.
I see. Go ahead.
Chief, just to clarify, we can go ahead and we can donate this, and operationally you're able to maintain everything that you need to do.
Absolutely.
Okay, thanks. Yes.
Anybody else? Okay, Chief, thank you very much, sir. All right. That completes the agenda. Let's go back and see what we got coming up next. I know everybody's just waiting for a presentation on personnel rules and regulations. This is the first of probably what will be two presentations. We'll go through this, and please, council members, ask as many questions as you feel is necessary so that staff can be prepared to bring this back to us in December, I guess, for approval. Okay? So we're going to start with Assistant City Manager.
Thanks, Mr. Mayor. I just wanted to take a minute and go through the extensive process that HR went through to put this draft together. And first, I do want to make it clear that this is a draft. It's not on your agenda for this week, as you've just finished hearing the agenda. And so although we have completed our review with the employees, council is still welcome to make any recommended changes. And so this draft is the end result of what's been over 2 years of work by the HR division and many other staff. The HR division began the process of reviewing the current personnel rules and considering changes back in September 2016. And that review included going through issues that had come up with the current policies, including areas with repeated misinterpretations, new laws that have gone into effect, removing procedure where it made sense, and sticking to policy, which administrative directives should be merged into the personnel rules, research with other cities and their policies, information in the employee handbook that wasn't in the personnel rules, and any conflicts between the personnel rules, admin directives, and the employee handbook. And so that process took approximately 8 months, and back in April of 2017, the first draft of the new rules was shared with the department directors and the employee council. There was a ton of feedback from those groups, as you can imagine, as well as individual employees and groups of employees. Over the rest of that year and into 2018, HR met with those individuals and groups who wanted to share their feedback, met with the employee council to discuss the personnel rules 11 times, and held more meetings with the department director group. And so along the way, HR staff also put together a 36-page Q&A document for the employees referencing the recommended changes, questions, or comments regarding the previous drafts, including reasoning on why certain recommendations were not included and the final recommendation or response to each particular issue, which was then sent to all department heads and the Employee Council in September. HR consulted with the city attorney, our risk management attorneys on various issues, and continued to research issues that came up as concerns or recommendations from the directors and the Employee Council. Then the individual final draft rules were sent to all department heads for additional and final feedback in July and August of this year, and the final draft summary of changes and that Q&A document were sent back out in September to the department heads and Employee Council. So as you can see, it's been a really extensive process. The HR division has put a lot of work into this. And with that, I will turn it over to Barbara to continue with the presentation.
All right. Good afternoon, Mayor and Council. Move this so I have room for my notebook here. So I put up an agenda kind of first just to kind of give an outline of what I thought would talk a little bit about today. I'm going to go over the history of it a little bit, the overall changes, the work with the Employee Council and the request and the things we looked at with them. And then what I titled the elephants in the room, the things that, you know, they're still not, staff aren't still real happy about, and then kind of go over the major changes by the rules. There's 15 rules in the actual proposed PRR draft that you have, but we're only going to go over 10 of those today. And the reason why is that 5 of those, there's no substantial changes in those. There hasn't been much question or anything. Those, just to let you know what they are, is the safety and training section, the employment records, the performance evaluations, and the probation area. Okay, so they are included in the draft. I just haven't included anything actually in the presentation of those. To kind of give you a little bit of difference, the current personnel rules and regulations have 17 rules, and again, the proposed has 15. We'll be reviewing 10 of those today. So go ahead and talk a little bit about the history. Maybe I will, if I know how to make this move. All right, I do. Okay, so the Personnel Rules and Regulations Ordinance that we are currently operating under was established in 1977. So I will say it has served the city well for the last 40 plus years, but we felt like it was time to do a complete rewrite. So we didn't take the existing personnel rules and regulations and edit them. Instead, we started with a complete new rewrite. So you've never seen, and neither has the Employee Council, anybody else out there hasn't ever seen really what we'd call a redlined version. We kind of started with the current draft, took some feedback, and then we started with a complete new rewrite. So between 77 and now, when it was established, there's been 36 modifications to that ordinance. Along with that, we have 24 administrative directives that deal with personnel and HR issues that are out there and existing. A lot of the reason for that is because there's been really significant changes in employment law since that time period. Some examples of that are the Family Medical and Leave Act, which is a large piece of legislation, didn't come into play until 1993, so again, it predates this. But we do have it as an admin directive, taking that admin directive, merging it into the actual personnel rules and regulations, which I'll often refer to as the PR&R, gets it in one location and gets that added. Also, a couple of years ago, specific to Arizona, we saw Proposition 206, the Sick Leave and the Minimum Wage Act came into play for us, so that's now been incorporated into that. I'll discuss that in some detail because there's some significant changes that came about with that we've currently added into the personnel rules and regulations to be in compliance with that. And we actually are in compliance with it, being that it's a state statute, but we've brought it into our own personnel rules and regs. ADA, the American Disabilities Act, came into play in 1990 with big amendments to that in 2008. And then YSERA, which is the Military Service Reemployment Act, also came into play in 1994. has been built into this one. And then there's some things that are prevalent just in employment law and cases these days that were not included in the policy and probably not necessary back then that we've gone in and added, and that includes the workplace violence, workplace bullying, and sexual harassment situations there. So any questions to that point? Okay. One thing that we be looking at proposing is for the personnel rules and regulations to be approved by resolution versus an ordinance. A lot of discussion with management and legal stuff went into that, and so we went back and we did a lot of research on that. And in Arizona, out of the 34 cities that we were able to get the information, only 5 of those have their PRR as an ordinance. All the remaining are doing it as by resolution. So you have a personnel ordinance, but your personnel rules and resolution, making them when things like, FMLA comes in or there's a change to FMLA, those can be changed and amended by resolution. Okay, so the overall changes I talked about, it is an overall change because it's a complete rewrite. And again, we've incorporated the various personnel rules and regulations that are in the policy now, amended and updated as necessary. We've also brought into play most all the administrative directives, which cover the varying federal and state laws that are applicable to us. We also had a part-time employee handbook and a full-time employee handbook. So with the PRR, we had the 2 handbooks and then the administrative directives. We have brought all this together into the one document. And so you see a lot of different things added in there. One note as far as the presentation goes today versus your draft that you've got, because we've incorporated full-time and part-time employees into the personnel rules and regulations, you will see in the actual draft things, it's called out in there. It tells you what's applicable to full-time, what's applicable to classified, what's applicable to part-time, but I did not necessarily cover the separation in the presentation today on which is applicable. So, of course, if you have any questions, feel free to ask me. To go this time, every time. Okay, so information that currently exists within the administrative directives have been combined. So we are going to be rescinding 12 administrative directives and eliminating the full and part-time handbooks if this proposal is taken like this. So that will be a big change in a lot of different documents that do not have to be out there, be getting them combined into one place. We also did find that with the handbooks and the varying different policies out there that we had some repetitive information, so we've eliminated that repetitive stuff. A lot of the admin directives that we've brought into place, for example, classification and compensation were merged into one rule in the new one. They were 2 separate ones, but we also had several admin directives out there, one on education and continuation and training, standby and call out, and travel time in compliance with the Fair Labor Standards Act, and some overtime admin directives. Those have all been brought into the personnel rules and regulations, would not need to be separate. We've also placed in the leave of absence, FMLA, which is the Family Medical Leave Act, also the holiday, which is currently a admin directive, and also inclement weather, which we are proposing calling that emergency closure, as opposed to just inclement weather, just for the other. We've added in, so in the drug and alcohol policy, we have 2 admin directives for things that have come into play after that. We've got one on prescription and over-the-counter medication, and one on the prohibited use of medical marijuana. Those have been brought into place. And we've also placed the recruitment, selection, and hiring, background investigations, all into the personnel rules and regs, and as well as employment records and the general provisions that are in the current one we've brought into, like to the code of conduct in various areas there. Again, we'll be eliminating a lot of the personnel rules and regs and bringing in, like, for example, one that we have a lot of rules and regs on because it's a really heavy compliance area. We have to follow under the Department of Health and Human Services, and DOT is on drug and alcohol testing. We have brought all of that into the personnel rules and regulations as far as the varying policies and stuff go. Any questions for that part? Okay, so as Victoria said, and we've talked about, we had many meetings with the Employee Council, and the Employee Council reviewed the personnel policies and procedures, and they made some requests during that time period. And so I'm going to go over the formal requests that they made. The Employee Council wanted to remain in the personnel rules and regulations. So originally we had looked at removing the Employee Council from the personnel rules and regulations with the intent to design another form of communication and employee feedback on that. We had done some research on it and what other cities had done and looked back at some changes that had been made to the Employee Council at the Employee Council's request in 2011 and looked to remove that. The Employee Council wanted to remain in there, and so we did go ahead and put that back in there. We did make some structural changes to that, which I'll cover more in detail. There don't really seem to be any opposition to the structural changes. They just wanted the Employee Council to remain. Another request was for employees that transition from full-time to part-time back to full-time to maintain vacation accrual seniority. And so when somebody goes full-time, they accrue a certain amount of benefits. If they go back to part-time, they don't. If they come back, could they, go back and pick up their accrued time? And so we talked with them, discussed that, and we had a management meeting on that, and the decision between the management team was to go ahead and grant that with the maximum of 5 years, including those who leave city service.
Could you explain that a little more? I don't understand the 5 years.
Mm-hmm. So, sure, absolutely. You accrue time based on tenure in the position. And so let's say, for example, I had 7 years with the city service full-time, and so I was accruing at the 7-year. And then I decided to go part-time, and say I went part-time for 3 years, and then I returned to full-time service. They didn't want to start over with the 0. They wanted to be able to pick up their prior full-time tenure. And so we did make an allowance for that to happen as long as the break in service, either from the city or from full-time to part-time, was 5 years or less.
I see.
They could pick that back up. So did that clarify that?
That did, thank you.
Okay, you're welcome. So we did grant that, and then they wanted to eliminate the 6-month promotional requirement, and we saw no real problem with that. We actually find that to be very beneficial. So to kind of explain what that is that in the current personnel rules and regulations, an employee has to be on staff for 6 months before they're eligible for an internal promotion or internal job posting. So in order for them to apply, it had to be open to the public. It couldn't be internal only. Again, they wanted to eliminate that 6-month period there. So we did go ahead and put a proposal in there that would allow for that to be eliminated. So there's, if you're working for the city, your 6-month tenure is not going to matter. If you've been here 1 month or 2 months, you're considered a city employee, and you would be eligible to apply for those. They may still have to go through the competitive process and all that, but they're applicable to apply. So we feel like that's a really good situation, especially, like I say, we've got a part-time refuse driver out there that is doing really well, and we've got a full-time position open up, but they hadn't been here 6 months. We would have to go to an outside recruitment for them to be eligible to apply. So that eliminates that requirement.
So then it would eliminate you having to go to outside recruitment if, okay, got it.
Absolutely.
That helps.
Yeah. If we've got internal candidates that are part-time, we can do that.
Who are eligible.
Yeah, without the 6-month waiting period.
Got it. Okay, thank you.
Okay, so they requested that, and that was granted. So they also wanted to maintain the 10% promotion. So this has been a big topic of conversation since the implementation of the class and comp plan in 2015. If we think back to that when the consultant came in, we discussed in many of the meetings with the employee groups, as well as the council groups, the management meetings, that 10% was going to be hard to sustain with the new class and comp structure.
So what we're talking about is when they get a promotion, their salary goes up 10%.
Correct.
Automatically. I just
yeah.
want to make sure everybody understands that.
Yeah, so I clarified that. So yeah, currently in the personnel rules and regulations, if you promote within city service, you get 10% or the minimum of the classification of the job you're promoting into. Okay, so the change would be that it's not going to be 10% anymore. It's going to be 6% or the minimum of the classification. And the consultant had recommended that be 5% based on sustainability and what they're seeing in other similar class and comp plans. We ended up going with the 6 because we ended up going with 2% steps. So to make it even 3 steps, 2, 4, 6 versus 2.5 steps at 5, we went with the 6. But the employee council did request that we keep that at 10%. We again went back to the management teams, went back to the executive, went back to the directors' meetings, and looking at budget, looking at the new class and comp plan, as well as the minimum wage increases and stuff, that we weren't going to be able to sustain the 10%. So we have kept the 6.
Barbara, can you just, or Chuck, either one, just explain why the 10%, not only for budget reasons, but also when someone got promoted, what we were looking at with issues, which employees kept coming to me about. But can you explain to the rest of council why that was an issue?
Mayor Mueller, Councilmember Gray, we've had the 10%. It predates me, so that's how long it's been in the personnel rules and regs. So. And essentially, what happens a lot, which is an unintended consequence, certainly you want to reward somebody for being promoted, but inevitably, it seems like almost every time when somebody gets promoted, their pay then advances beyond incumbents that have already been in the position for a period of time. And what that basically forces us to do then is calculate what it takes to bring everybody up to that level. So not only does the promoted employee benefit from the 10%, but it turns out many employees benefit from somebody getting a 10% raise. So you can understand why it would want to be remain in place. But for example, this latest round of police department promotions where we had an individual promote from sergeant to lieutenant, that situation existed. Chief came to me and calculated an additional $21,000 would be required to bring people up to that level, because it rolls through the entire system. It went from lieutenant to sergeant to corporal and down the road. So we needed to do something to stop that from happening in the future. So the 6% should take care of most of that issue. Probably won't take care of all of them, but we'll certainly mitigate it.
And I'll just reiterate that the 6% is not going to be a complete solution, but it would certainly help. And there is just simply no perfect system out there that exists there. Okay. Any other questions on that one, since that seems to be one of the really big ones? Okay. Next was they had asked for an explanation of rights for the accused and detailed outline of the process of an investigation. So we did grant that as a general description and not a detailed process. And how that came about is we had very extensive legal counsel, both our internal Nathan and as well as our risk management employment law attorneys look at that and review that, and both of them do not support putting any details in there. They have due process rights and stuff, and those are in there. When I say we granted general descriptions, we put all that is required in there. And again, just after very extensive work with the attorneys, we put what they felt like needed to be in there. And as well, and originally that said like the police, and just to clarify, there's a police officer bill of rights, but it's a different situation. That's their rights when accused, in a totally different situation.
Does that mean that everybody gets this explanation of rights, or the accused? gets I don't quite understand how that
And,
plays out.
Yeah, they wanted a more detailed explanation of rights, and so
To who?
the accused.
Oh,
Yeah.
okay.
If you know somebody files let's just say it's a harassment complaint against you, they wanted more detail of their rights. And so we put general detail in. So we did grant that. We just we're not able to put it in as much detail. Every situation is a little bit different. And again, we went with the attorneys on this one to resolve what needs to be in there and what does not need to be in there.
Oh, okay, just one more little piece for the, do you have more? Okay.
Yeah, hopefully I can clarify too, the situation, because there are a number of different types of investigations that go on for a variety of, personnel situations that come up, be it a grievance or harassment, as Barbara pointed out, to something that could involve criminal investigation or a large-scale administrative investigation, in which case we would bring the police department into those. And there are certain rules they have to follow for certain types of investigations that should be explained to whoever's being investigated. And really what we needed to clarify more was the more minor investigations, because I don't think it was clear to the employees exactly the process, that we go through for those types of investigations.
Yeah, and as you stated, just to be clear, this is only administrative investigations. This is not criminal, so that would be turned over then to the police, and it would fall under the completely different situation. These are just administrative. Okay. So they also ask us to explore options of incentivizing overtime, and we spent quite a bit of time discussing this and stuff. So as it stands right now, we pay overtime in compliance with the Fair Labor Standards Act, which is the federal wage and hour law. So how that is working is that you are paid overtime on any hours worked over 40 hours. So to better clarify what hours worked are is, let me say that I work a 4-10, okay, normal week for my 40 hours. But on Monday and Tuesday, I take vacation of 20 hours, and then I come back to work on Wednesday, and I work my 10-hour shift, and then I'm on Thursday, and I have to work 2 hours over because I had something going on that kept me over. So I've got a total of 42 hours, but I only have 22 hours worked. No overtime there because it's not exceeding 40 hours on the actual hours worked. And so they wanted us to look at adding in overtime pay for things like holidays, sick, and vacation. And that was brought up to the employee council, and that was put to a vote. It did not pass at employee council to recommend doing that change. And that was after we talked about cost, we talked about the new class and comp and the budgets. But what they did come back and do is they put a vote on for us to look at some options for incentivizing that. So in other words, perhaps just doing it for holidays, when there's a week where there's a holiday, per se. And so they have to be off for the holiday, and then they end up, let's take Thanksgiving, for example. We're an 8-hour employee. We work 3 8-hour days. We work 24, and then we've got 16 hours of vacation, and we get a call out on Saturday. Still in that pay week. We work 4 hours. We're still not getting overtime. We're getting regular hours because the actual hours worked are not above 40. Let's go away.
So underneath so we're using FLSA, and we're using exempt and non-exempt labor categories, correct?
Correct.
So our exempt employees are all getting straight time overtime, if that's what we want to call it, and then the non-exempt are getting what, time and a half?
Yes. So exempt employees receive no overtime at all. It can be 45, 50, 55, 60 hours. Exempt employees don't receive any overtime. Our non-exempt employees, they receive time and a half for any hours worked over 40, but that does not include paid hours that are not actual hours worked.
All right.
Did that make sense?
Oh, no, yeah, absolutely.
Okay. And so the suggestion was brought up to look at it maybe just on holiday pay. The other suggestion was to look at it just on sick time pay. Like if they have to be out sick, could they get it? And the other was to look at it just on time when they've taken vacation. And the other was to look at it for just public safety. I mean, the police and fire where they're running 24/7, 365 operations. So we did have a management meeting about this. We discussed this, you know, in depth in the management meeting. Did not feel like this is something that we can get in the budget and sustain at this time. A couple of reasons for that. One is that we are doing the 2%. We did do the 2% this year. And of course, we looked at this as past budget season. And then we also looked at the fact that with the 206 and the minimum wage increases, we're going to have to be doing some sliding scales because some of our classifications are crashing into each other and stuff. And so there's some changes that are coming forward there, and there's a price tag that are attached to those. And so we went back to the employee council and we let them know that this year we don't see this as viable as a possibility, and that we would look at it again in the next budget year.
Thank you for that explanation, Barbara. So if other options and management decides to do other, I'm not, at this time, I can't feasibly understand why there would be, but we'll see what happens. But will that have to come back to council to add to policy, or is that just going, will that be an admin directive? How will that work, Chuck?
It would.
If it's in the actual personnel rules, and that's one of the reasons for adopting by a resolution, much easier to change, but it would have to be changed by council by resolution.
So we'll hear about it, I guess, was really what I wanted to.
Yes, it would be brought back, and what we would be doing would be amending the class and comp rule.
Okay, thank you.
You're welcome. Okay, so talk about some employee council updates on the structure. So we took the membership from 16 to 11 in the executive committee from 3 to 2. Talk about a little bit of the history there. I couldn't find out exactly what year the employee council came into play, but I could find records back into 2000 and slightly before that. And I do know it existed, but I really can't give you an exact time. But I will tell you that during that time period prior, whenever 16, we had larger numbers of staff as well, larger departments, and then there's been some structure changes. For example, parks maintenance moved back over to leisure, and some of the tourism moved over to marketing, and those individuals had representatives on the council that really didn't exist in that capacity anymore. So kind of did a simplification of the restructure there. There hasn't been any real concern or real comment about that, the restructure there. The representative terms of 2 years, maximum of 4 changed to 1 year and a maximum of 2, and that was to keep opportunity there for change and for new perspective and new people to participate in that. And then they had requested that we open the membership up to unclassified employees. So we took a look at that, and the concern with doing it with unclassified employees is 2 things. So an unclassified employee is either 1, a part-time employee, or 2, an employee within their initial probationary period of the first year. So really felt like in general, unclassified employees may not be as in tune with the department and the staff if they're just there part-time, or if they're fairly new, and that might be, you know, somewhat of a concern. But we did, in talking with the council, the department directors, the management and stuff, go ahead and open up the membership to unclassified employees with department head approval.
You agreed to do that?
I'm sorry?
You said you agreed to allow those folks to be on the employee council?
Yeah, that's what we've proposed in here. And it gets the employee council request. And again, after discussion, that if the department head is okay with the unclassified employee, you know, maybe it's a really long-term part-time employee that's been here for quite some time and has something or whatever. So if the department head is okay with that employee serving, and understand too, those positions are voted on by the department as well. So we went ahead and opened that up.
Good, thank you.
What's the role of the executive committee?
The executive committee is the chair and the secretary. So historically we had a chair, a vice chair, and a secretary.
And
They run the meetings is I think what the
Yeah,
answer
put
is.
out the agenda, schedule the meetings, and then the secretary keep the roster, keep the minutes, post the minutes on the internet, and that type of thing.
Okay, thanks.
You're welcome. Any other questions on any of that?
I do actually
Yeah.
have a quick question. So we went from 16 to 11, and
yes,
we don't have 11 departments, I don't think, do we?
No, we don't.
Okay.
So on our larger departments, we have 2 representatives.
Okay, so like
And-
Public Works. I'm
Yes,
assuming
Public
would-
Works, Police, Fire, Leisure and Library. And that is really to keep it representative of the number of staff in each of the departments.
Okay, that makes perfect
So-
sense. Thank you.
Okay, you're welcome. Anything else there? Okay. Moving right along.
Are we still on employee council?
Yeah, do one more slide. You have something on that?
I did have a question. I'm not sure if it's answered in that last section. The question is, do employees on the employee council get any kind of training for doing, they handle some pretty heavy issues. Is there any special training for them?
We have brought in different trainings for them. For example, one that came up a few years ago was that there was some requests at looking at like the employee medical and the self-insured and some different maybe ways to set that up and stuff. And so we work with a consultant on self-insured funds called Aaron Collins and Associates, and we brought them in to do some training with them on self-insured and sustainability of the plans and things like that. We also, anytime that we're asked to come in and discuss various things, like we've been asked to come in and talk about like travel pay and various things, we'll always come in. And if we don't have the resources in-house, we'll bring somebody in. We've also had the attorney and, you know, different things to cover various things there.
Are they permitted to request any particular kind of training?
Absolutely.
Okay.
Yeah, all, even employee council for sure, but actually all of our employee groups from departments to different sections, they are all welcome to request any type of training, and we'll provide that if we can. And I honestly can't think of any time we haven't been able to.
Okay, thank you.
You're welcome. Okay, so moving on, they have 2 special meetings in addition to the quarterly meetings, and they can request additional meetings from the city manager. So I know that came up a while back about the quarterly versus the monthly. So just a little history on how that happened. In 2011, the employee council made a request to have the meetings changed from monthly to quarterly themselves, and that was brought to the council in 2011, and that change was made at that time. They, at that time, felt like the monthly meetings were difficult and maybe too many, and that they weren't getting quorums and various things, and so they made that request for quarterly. We did not deviate from that. We left that at quarterly. Okay. And then another request was that employee council be given no less than 30 days. Actually, it's not necessarily a request. We put in that employee council will be given no less than 30 days to review any proposed changes to the personnel rules and regulations. Little history on that is that currently, our current says that they are giving 2 scheduled meetings, which ends up being 6 months, which, as you can see, we went back because this took a long period of time to get through that. Here's what I think on that is that when that change in 2011 was made, and it went to quarterly, instead of 2 regular meetings, the quarterly meetings ended up making that 6 months. And so we went in and changed that just to read that they would be given no less than 30 days.
But the other point to make, though, is you got quarterly meetings, and they can ask for an additional 2 meetings. And I would hope when they have serious issues like this to review, they can ask for an extension, and that would be granted by the management.
Oh, yeah. And they have 6 actual meetings that they don't need permission to have more, because they're 4 quarterly and the ability for 2 special. But like, I think
What I'm talking about specifically is on this where they have 30 days to make the changes.
Yes.
They can request to have a couple extra meetings and extra time if it's going to take that long to do.
Absolutely. And that happened this round. Victoria covered that a while ago. I can't remember. Did you say 11 is that, so there were 11 total meetings for the personnel rules and regulations. So anytime they asked, those were granted. So. And then the last on that slide is that we removed the requirement for the city manager to take employee council recommendations to the mayor and the city council. So basically, we brought that in line with 3107, the powers and duties of the city manager, which says the city manager form of government, and 3107 is our own ordinance. And it's the duty of the city manager to recommend to the council for adopting such measures and ordinances that he deems necessary. So the staff work for the city manager, and so instead of those, the way it's written and the way it appears right now is that those go straight from the employee council then to the city council, and so we put in there for them to go from the employee council to the city manager. Questions or concerns on this page?
I guess just for the sake of discussion, so if there was a requirement for the city manager previously to bring things to council, has there ever been a situation in which, I haven't, 4 years being up here, I don't recall too many times where you brought anything that that was kind of brought up? Is that,
Well,
and that's not to be accusatory, you know what I'm getting at. I mean,
Yeah,
is this
no,
a
I
real
understand what
problem,
you're
or is this something that is not really that big of an issue?
Well, I think in terms of context, looking at this, basically what there was a conflict between the personnel, what the personnel rules said, and what the actual city code of ordinances says. So this was brought to the city attorney, who opined that the city code of ordinances took precedence. So this would clean up that particular language. But to get back to your specific question, this is a very rare occurrence. It does happen from time to time, but it's not something that occurs, on a regular basis.
So for me, it looks like the trade-off here, and I assume these are recommendations that have been worked out already. That's what it is. So the trade-off is a few less meetings, but they can request more meetings if need be. They have a deadline in order to kind of come to terms with whatever it is that they need to do. And if they can't come to the deadline terms, they can request more information. But once they do their due diligence, it comes up to you, and then you bring it to us.
Yeah, and I can't recall a time where I haven't granted them extra meeting times if they desired it. So.
And I can say in my tenure since 2013, they've never been denied the additional meetings. And I can also say that in my tenure, there has never been a formal request where they vote and they make their request to send it to the mayor and city council until this. And we just went over those, that there hasn't actually been one. They've made a lot of recommendations, they've made a lot of requests, but they haven't made the formal request for them to go to city council and to manager. Some of those changes along the way they knew we were making anyway, and I'm going to cover some of those a little bit later in the things that have been discussed where they never made the formal recommendation. They just asked us to look into it, and we did, and we gave them the feedback that we're making the changes.
Thank you.
Mm-hmm. So this is because I've talked about, these were all employee council recommendations, but these have also been things with other staff. I went ahead and kind of just wanted to clearly identify what I called the elephants in the room, the things that they weren't happy about. And again, we've talked about them in detail, and that's the promotion change from the required 10%, which would be reduced to the 6%. Also, that we are not at this time able to incentivize overtime. And then the removal of the requirement for the city manager to take the employee council recommendations.
Barbara, I'm still a little confused about that one, Chuck and Barbara. What's you handle employee issues. Mm-hmm. I don't understand I guess there's no issue if you've never had to bring anything.
Yeah, I've never actually formally received a voted on request by the employee council to bring something to the city council.
Okay.
So
okay.
Essentially, my job is to make recommendations to the council on everything that comes up has to have a recommendation, and obviously personnel stuff is part of that. Of course, they would like to be able to bring things directly to you instead of going through me. So that's the difference of opinion.
So this is not about directly bringing things to a council member. This is about them formally making a request from you, of you, to come to the council.
Yeah.
Oh, okay. I see now what it means. So, okay. Okay. I think your job is to handle, between you and your department heads, to deal with
and
all
for the
those
most part,
employees.
yes, they are handled. Otherwise, you would get more requests, or I would get requests. So,
okay.
So the record shows that they are generally handled.
Okay, I think we're going to cover a little bit more about grievance and all of that, where folks, they handle everything through the, okay.
Yeah, we're absolutely going to cover that. We can get through that. So we can go through those. So the Code of Conduct is a new policy, but it's been created from the Statement of Principles. It's in the current rule. It's also brought in a lot of things from the employee handbook and stuff, but some of the bigger things, it added a list of values, of course, standards of conduct, confidentiality, the loyalty oath, which that's required under state law, that each city employee take the loyalty oath, and then a code of ethics. And the code of ethics was passed by the council by resolution sometime. We just brought it into the personnel rules and regulations to keep it into a consolidated. And also the equal opportunity section, we did a few things with that. We removed the EEO specialist. We removed the unnecessary verbiage and updated to current EEOC guidelines. And we added the YESERA and the ADA, which again I talked about at the beginning. Those came about quite some time after this policy was put in place. And so we've had them as admin directives, but we wanted to get them in all together. So not really, most all of that stuff right there is federally regulated, because ADA, YESERA, FMLA, all that is federal law, and so we just brought it into place. And a few years back, we talked about, we kind of did some revisions. I think that was the actual last revision to the ordinance that I brought to the council on the EEO policy, and we went ahead and did some updates at that time to come into compliance. But this really gets it in line with exactly where things are today. Are there questions there? Okay, so also in the Code of Conduct, we've updated the harassment and discrimination to go with current EEOC guidelines, and we've updated the procedures. Big thing is we've removed the timeline for reporting and have just said report immediately, and updated who it should be reported to. We've added some different options on people that you can report to, and updated the communication portion with the affected parties. So talk a little bit about the timeline. The current policy stated that it must be within 90 working days. That's not within, the guidelines. It should be reported immediately, and so that's our wording now, is that it should be reported immediately. And also, we would review any requests that meet the EEOC timelines in that, which is 180 calendar days from the date of the event, and it can be extended to 300 calendar days. And then Arizona has the same 180 days as EEO, so we would allow that timeline. Yes?
What do you define as immediately?
As soon as possible. In other words, if you have a harassment or a discrimination claim that you believe somebody has harassed you or you've been discriminated against, we want that complaint filed immediately. We don't want you to wait like 90 days or 30 days or whatever. We want the complaint to be filed immediately. And again, we will allow them to file within the EEOC guidelines, which is the 180 days up to 300 in certain circumstances. But sometimes people will hold off on filing, and that can, lead to where, let's say you've got a harassment situation going on, there can be more situation and more circumstances happen if we don't get it reported immediately.
Well, I completely appreciate the situation with the trauma that would be involved. what I'm looking at, though, from procedurally, especially legally, we have a set of guidelines that are set forth by the federal government on this.
Correct.
And then what happens, though, is if we say they must report immediately and we haven't defined immediately, are we not setting our own employees up for some sort of arbitrary questioning, I should say, as to why, if we can't define it, they've got a deadline already, and then if we say they must, I mean, I'm just wondering, when we use words like must in a regulatory sense, then we should probably have something that clearly delineates what the timeline is. That's my assumption, just because right now we're both kind of confused on what immediately even probably means.
Right, as soon as possible. And so, yeah, we can look at adding a definition to that. It is in the EUC recommendations is to have people report immediately. That's on the Q&A sheet.
And maybe
we'll
it's
see
just
if
a
we can.
recommendation to report it immediately, but no later than the federal.
Well, clearly we have to work within the federal guidelines.
Right.
So the time frame is already established.
We have that.
What we want to see, and perhaps the better word is encourage people to file the complaint, as quickly as possible, immediately, or whatever that word needs to be, because it gets harder and harder to investigate, those types of complaints the longer they go on. So it's easier to resolve them the quicker they're.
Absolutely understand. I simply want us to eliminate any burden on the person who has had the harassment conducted to them by, the first question would be is, why didn't you tell us sooner if we can't identify immediately? And so to simply remove that, and I like the idea of using encouraged, you're encouraged to immediately report, then it eliminates anything that says thou must before the deadline.
Yeah, we can change that.
And just to clarify, because I may have misspoke on this, it does say should report immediately. It does not say must.
Okay, thank you.
It says should, and then it also states that they have the full EEOC time, which is a minimum of 180 days.
I'm a stubborn person. When somebody
It's
says
okay.
must, my
No,
ears
I
perk
think
up.
I misspoke on that because she stood up and she said it just says, should. And so we didn't make it a must. And again, it's just encouraging people to report things that we may can stop or prevent or separate people immediately before it gets worse.
Thank you.
So are we good with that, or do you want us to look at that a little further?
No, if you say it says what it says and it's not what this is,
Yeah.
then I'm perfectly happy with it. I just don't want to bind somebody with a rule that we can't define.
No, and I absolutely understand that, and they looked that up, and the draft definitely says should.
Okay, perfect.
And so
No,
I
think
misspoke on that.
I think that's fantastic.
Okay, thank you. Okay, and then we talked about the rights of employees, and so we added the section related to the employee who's accused, and I talked about that earlier, just in overall investigations. And so unless you want to talk about that more in depth, it's the same. I'll just go on through that one. And continue on with the code of conduct. This is just a list of things that were added to the following sections that we felt like should be, in the code of conduct there. And again, I can talk about any of them that you specifically, are interested in, but the criminal convictions I will highlight out there because there was some discussion on this with employees. And so it's been added that employees must report arrests to us. And, there's many reasons for that. This was added first off by our risk management attorney for employment law. And there are many circumstances where the employees, based on their licensure, have to do that as well. And I'm going to give you a couple. An AZ post police officer, they must report already just to hold their certification. Also a paramedic who's got narcotics and the ability to administer narcotics must report. And also all of our CDL drivers that based upon their license must report those. So we've incorporated that to all employees, and for many reasons. For example, even prior to a conviction, like say in a DUI, you can get your license pulled prior to the conviction. If you're driving for the city, we need to know about that.
Just a kind of a sidebar with the arrest. The employees must report their arrest. Forgive me for not knowing. Does the city have any employee, without going into detail, do we have employees who carry security clearances at all? in order to conduct things?
Yes, we do.
We do? Okay. I was just curious.
So then the other thing is that EEOC has issued a fairly large guideline on the reporting of arrests and stuff, and so we have also adhered to that within the rules and regs. Any other questions on the list on code of conduct? On recruitment, selection, and hiring, this is added as a new policy. We've incorporated the information out of 5 current rules into one and just done some clarification on the overall hiring requirements, practices for postings, exams, internal transfers and stuff. And probably the biggest one on that we talked about is that they're no longer going to have the 6 month as an employee before they're eligible for the internal. We've clarified that and straightened that up in there, made it clearer. We've also changed the residency requirements. So those of you that were back on the council, it wasn't too long after I got here in 2014, we had a big meeting on this. We had a big discussion about this, and we agreed that as we move forward down the road in looking at this and changing the personnel rules and regulations, that we would look at this and we would revisit this. And so we've done exactly that. And so our proposed is, as you see on the screen, and just to kind of bring you up to what it is currently, is that our current residency requirement states that you must reside within 10 miles within 1 year of hire, and the city manager, assistant city manager, department directors, and sworn police officers are the only people that that's applicable to. So the reason for the change for the sworn police officers is, one, to be able to expand our applicant pool. The others to reduce the overtime by removing the barrier and opening up applicant pool, in the hard to fill position. And also the 15-mile limit for take-home vehicles. We're not going to be allowing them to take the vehicles home after that, so there wouldn't really be any added expense to that. And then we went through some very, detailed discussions and stuff with the police chief on that to come up with that for the officers. And then we made the recommendation based on the notes and stuff from the discussions that we had a while back to review the actual residency requirements.
I've got a question for the chief. How many officers right now do you have that live 50 miles away from us?
We have a couple that live right there at the limit right now. We have multiple officers that do live outside the city limits, but we've had many applicants from, say, Benson, Vale area that don't really want to leave the school systems there, but really would like to apply. This would also expand down all the way to Douglas, I believe, that area. But we have multiple officers that do live within that 15 mile that are outside the city limits.
I know I understand the 15-mile limit. I'm talking about the from 15 to 50.
Currently, we have none because of the residency requirement. They all move in with that 15-mile radius.
Yeah. So I just question is why we have that 50. So you guys need to look at that.
I thought we were changing from 15 to 50.
Yeah, to open up the.
So you want the 50 mile
yes.
for the recruiting.
That's correct.
Okay, got it. Thank you.
I need to go back to the code of conduct, and I apologize. I had to borrow the mayor's document so I could look at it. So on the whistleblower policy, it very clearly states if someone has an issue, they need to come to you or to the city manager. I thought that the whole purpose of a whistleblower was so that they were not identified, so they were able to report something that they saw without having to identify who they were. Obviously, that's very impossible if they're coming to one of you. Right. So I see a lot of companies that set up hotlines, that set up those types of things. Why are we not doing that?
We could do that. There isn't a requirement in the whistleblower legislation that requires them to be, they can't be retaliated against. Right. And we don't necessarily have to disclose, who reported and stuff like that. But I mean, there is always the possibility of setting up. I will just say that in my 17 years of doing this with the government, I've actually never had a whistleblower claim filed. In that, and in that, so I understood. And so, you know, what we did was try to give them varying people that would be like outside of their direct chain of command, outside of their area, and stuff like that, that they could report that to.
Okay, so I guess then, and when I said I've had two, not against me, I just meant in my
Right,
role.
in your role, yeah, I understood.
I needed to clarify that right quick.
Okay.
So I guess then my question is do we feel like there have been things that haven't been reported? And I know that we don't have a lot of issues with our staff, but we've had some. Yeah. So do we feel like those are things that maybe went on a little too long because people were intimidated by coming? I guess I want to make sure I don't propose having anonymous complaints with no basis behind them. That waste everyone's time. I completely understand that. I also, though, in the same vein, want our employees to be comfortable reporting issues that they see.
Absolutely, and so do we. And we want them to be comfortable with who they can report to. Right. So I will say that we've had a couple of things. They were not reported as whistleblower, didn't end up being that, but we've had a couple of things that were reported that ended up in some pretty substantial like audits and different things having to take place. I do not think they had any issue with the way that they were able to report it, and I do not think they were unhappy at all with the outcome of it. And again, we ensured all the protections of that, no retaliation, no feedback and stuff. And you know, again, they didn't reach that level, but I think it was because they felt fine reporting them as necessary.
Okay, thank you.
You're welcome.
Well, that begs the question, though, when you do receive anonymous complaints and follow up and look into them in great detail, how do you know how to let an employee know if they didn't tell you who they are, but there was follow-up to the concerns? How do you let people know that? 'Cause my guess is if that's ever the situation, that everybody knows. It's just kind of everybody knows what's going on. It's just it's done anonymously. So how do you deal with staff reassuring that there's no need for anonymity when you have these things set up in place to protect people, like the whistleblower rule?
Sometimes they don't want to be known as the one that, turned them in or whatever. And so we've had that situation where the reporting party didn't want to be known. And so we did not disclose who the reporting party is, but we knew who the reporting party was. And so we made that communication happen. And, with that, it can lead to speculation, and it can lead to we know who the reporting party is, but we just never disclosed who the reporting party was. But we did have the discussions and the follow-up, and we gave the conclusion to the reporting party. But, again, we just never disclosed who it was.
I see. Okay.
But we did know. We did know who the reporter was.
And there could be cases where you wouldn't. And, you guys are the experts in how to deal with that. But I think it's, I'm not sure if unfair is the right word, but it complicates issues if staff don't come forward. Important place for staff to understand what's in place to protect them should.
Absolutely agree with that. And one thing that if we move forward with the proposed policies and we put these into place, one thing that we're looking to do is to go out and maybe, like orientation revisited, but a lot of education. We're going to go out and spend a lot of time with the staff on talking about the new policies and the new procedures, and give detail and do Q&As, do small groups, do whatever they would like and for however long they would like. But we're fully anticipating when these go into effect, we're going to spend a lot of time out. It's been a long time since there's been significant changes and stuff, and we want to make sure that they understand them and that they have that opportunity to ask all the questions they want to. And then, you know, they may not remember everything, and we don't want them to, but what we want them to do is remember to either walk in and see us or to pick up the phone and give us a call on those things. And so we know that with the new policies and procedures, we're going to spend a lot of time with them. We're going to do a lot of education.
Okay, thank you.
Barbara, before you go on, we've reached our time limit. So, and I think we've gotten through everything except for classification compensation is the slide that we were going to. Is this a good break point so we can come back and finish discussing this at the next work session? We'll look at scheduling it then. Yeah, we have one scheduled.
I knew we did. I just
Yeah, it was going to be a relatively short one. Yeah.
Yeah.
Yeah, because we won't get through,
Yeah.
even if you extend it.
Even if we extend it, we're not going to get through it. So, if that's okay with you, Barbara, I just want to thank you for
I'm absolutely fine with whatever y'all like.
getting through that point. Any other comments or questions before we break?
Nope.
Okay, well, thank you very much.
Okay, thank y'all.
And with that, meeting's adjourned. Thank you.